So you are living the global dream, right? Like maybe you're a high-earning digital nomad, typing away on a laptop from some sun-drenched beach in Bali.
Oh, yeah. Or you're a corporate executive constantly bouncing between international offices and, London, New York, Mumbai.
Exactly. And, I mean, it sounds totally glamorous, doesn't it? But then the music just stops.
Yeah, you open your mail and realize you owe full taxes in two entirely different countries at the exact same time.
Right. And both of them want a very large slice of your income. So today we are doing a deep dive, basically tearing apart the rule book on dual tax residency.
It's a huge issue.
It really is. We are looking specifically at this highly detailed paper by CA Pooja v. Dedhia to figure out how individuals and companies get trapped in this nightmare. And, more importantly, how to legally escape it.
Yeah, and if we connect this to the bigger picture, this is arguably the most critical financial blind spot for anyone crossing borders today. I mean, with the massive rise in global mobility and remote work.
It's everywhere now.
Exactly. Domestic tax authorities are getting incredibly aggressive. It is not just a problem for billionaires hiding money in offshore accounts anymore.
Oh, definitely.
Understanding these rules is like the ultimate shortcut to protecting your income and, avoiding some really devastating penalties.
Okay, let's unpack this, because before we go global, we have to understand how you actually get caught in the domestic tax net in the first place.
Right.
India has built this massive, almost inescapable net under Section 6 of the Income Tax Act, or the ITA, for 2025. Let's start with companies. How does a business get flagged as an Indian resident?
Well, for a company, the net is cast in two ways. The first is pretty simple. You incorporated the company in India.
Makes sense.
But the second is where it gets tricky. It is based on your place of effective management, which is often abbreviated as POEM.
Oh, okay.
Yeah, POEM looks past the legal paperwork and asks, where the key management and commercial decisions that actually run the business are made in substance.
So it's not just about, like, renting a cheap office space, slapping a brass plate on a door in Mumbai, and calling it an Indian branch.
Oh, absolutely not.
The authorities want to know where the executives are physically sitting when they pull the levers of the business.
That is the core of the issue. I mean, if the CEO is making the major strategic calls from a laptop in Delhi, that company might be deemed an Indian tax resident, even if it is registered in Singapore.
Wow.
But for individuals, the web is much more layered. India doesn't just view you as a resident or a non-resident. They split you into three distinct tiers.
Right, 3 tiers. Let's go through those.
So you have resident and ordinarily resident, which we call RRR. Then you have resident but not ordinarily resident, or NOR. And finally, just non-resident.
And the paper highlights a massive, highly intentional shift here regarding how much time you can spend in the country. Historically, to give people a buffer, there was this transitional relief threshold, right?
Yeah, the 182-day rule.
Right. If you were an Indian citizen or the person of Indian origin visiting India, you could stay up to 182 days, basically half the year, without becoming a full resident.
Which was very generous.
But they recently dropped that threshold to just 120 days for high-income earners.
They did, and they did that specifically to combat tax avoidance. I mean, for years, high net worth individuals were literally counting days on a calendar.
It's just gaming the system.
Totally.
Yeah.
They would spend 181 days running massive businesses in India and then strategically fly out of the country to stay entirely outside the global tax net.
Unbelievable.
So by shrinking that window to 120 days, the government effectively closed a massive loophole.
They also added what the paper calls deemed residency provisions, which, honestly, this feels entirely targeted at the modern digital nomad.
Oh, 100%.
If you are an Indian citizen, you earn above a certain threshold from Indian sources, and you are not liable to pay tax in any other country.
Meaning you've set yourself up in a tax haven like Dubai or something?
Yeah, or you just travel so much you don't trigger residency anywhere. India will just magically deem you a resident.
It is a fascinating mechanism to capture stateless income. The government is essentially saying, if nobody else is taxing you and you hold our passport while making money from our economy, we are going to tax you.
Which brings us to the actual financial impact of these 3 tiers.
Yeah.
So the NOR category, the resident, but not ordinarily resident, is essentially a tax waiting room.
A tax waiting room. I like that.
Like, you're in the building, but they haven't handed you the bill for the entire buffet yet. They only tax the money you made inside the quarantine zone. They can't touch the money in your overseas accounts.
That is a brilliant way to conceptualize it. Yeah, your classification dictates your exposure. So if you are RRR, a full resident, the quarantine is lifted. You are taxed on your global income.
Ouch.
Yeah, everything you make anywhere in the world is fair game. If you are a non-resident, you are only taxed on India-sourced income. But if you are in that N/or waiting room, you are taxed on Indian income, plus any foreign income that is specifically linked to a business controlled in or a profession set up in India.
So moving from non-resident into that N/or status because of the new 120-day rule has huge ripple effects. Suddenly, money you thought was safe might get taxed.
Exactly.
But here's the logical problem. India has built this massive net, but the UK, the US, and Australia have built identical nets. What happens when two sovereign nations catch the exact same taxpayer in their nets at the exact same time?
And this is where we hit the fundamental philosophical divide in global taxation. Taxing rights globally fall into two main buckets.
Okay, let's hear them.
You have residence-based taxation, which argues you live here, you use our roads, our hospitals, our infrastructure, so we have the right to tax your worldwide income.
Makes sense. What's the other one?
On the other side, you have source-based taxation. That one argues you generated this income on our soil, using our market and our consumers, so we tax it, regardless of where you actually sleep at night.
And since most countries are greedy, they use a hybrid of both, right?
They do, and that creates a massive collision. Imagine you live in country A, which applies residence-based taxation on your global income.
Okay.
But you earn money from a client in country B, which applies source-based taxation on that exact same income. Both countries send you a bill.
Wow.
Or worse, as we see with dual residency, country A and country B might both claim you actually live there based on their differing domestic laws. One might look at your passport, the other might look at how many days you spent there.
So you are trapped. And this is where the paper introduces the lifeline, right?
Yes.
The Double Taxation Avoidance Agreement, or GTAA.
Yes.
Under Section 159 of the Indian Income Tax Act, this treaty steps in to mediate the fight. It assigns what we can call a winner state and a loser state.
That's right. The winner state is the country that ultimately retains the residence-based taxing rights on your global income. The loser state is legally restricted.
So they have to back off.
They have to step back. They can generally only exercise source-based taxation on the income generated strictly within their borders. And more importantly, the loser state is obligated to provide a foreign tax credit.
Let's make sure that is crystal clear. How does a foreign tax credit actually function so you don't pay double?
Let's say you earn $100,000 and the loser state taxes it at source for $20,000. When you file your taxes in the winner state, you report the full $100,000.
Right.
But instead of paying the winner state's full tax rate on it, they give you a credit for the $20,000 you already paid to the loser state. It offsets your bill dollar for dollar.
Oh, I see. So you only pay the higher of the two tax rates, never both combined.
Exactly.
Okay, that makes sense. But wait, does the DTAA magically erase my domestic residency? I mean, if the treaty says the UK is the winner state, am I suddenly not an Indian resident anymore? Can I just ignore the Indian tax authorities?
No, and this is where many people get themselves into serious legal trouble. The treaty does not erase your domestic residency. It only assigns single treaty residents for the very specific purpose of distributing taxes fairly. For domestic purposes in India, you might still legally be considered a resident in that N/or quarantine. You still have to file Indian tax returns. You still have to declare your foreign bank accounts.
So you're just using the treaty to prevent getting double taxed on the actual cash.
Precisely.
Well, here's where it gets really interesting. If both countries desperately want your tax money, and they both have a totally valid claim under their domestic laws, how on earth do they decide who gets to be the winner state? I'm assuming it doesn't just come down to what passport you hold.
Actually, nationality is way down the list. To decide the winner state, international treaties use what are called tiebreaker rules.
Okay.
For individuals, this is governed by Article 4.2 of the OECD Model Tax Convention. It is a strict sequential hierarchy, a gauntlet of 5 tests. You cannot move to Step 2 until Step 1 results in a complete tie.
Okay, let's walk through this gauntlet. Step 1. I assume it's about where you own property.
Step 1 is the permanent home test. But it is not just about ownership. The treaty assigns residence to the state where you have a permanent home available to you.
Available.
Yes. And what's fascinating here is how the OECD defines availability. It must be continuously available for your personal use, not just occasionally.
So if I buy a multi-million-dollar mansion in London, but I immediately rent it out to a family on a 2-year lease, I own it, but but I can't just walk in and sleep in the master bedroom.
Exactly. Because you gave up the right to occupy it, it does not count as a permanent home for this test.
That's crazy.
Conversely, if you don't own any property, but you essentially live in a specific hotel in Mumbai and have a long-term contractual right to always have a room there, that hotel can absolutely be considered your permanent home.
Wow. Okay, so let's say our digital nomad has a continuously available apartment in London and a continuously available apartment in Mumbai. It's a tie. We move to step 2 in the gauntlet.
Step 2 is the center of vital interests. This test asks a broader question. Where are your personal and economic relations closer?
Meaning what, exactly?
Personal ties mean your family, your social relations, your cultural activities, where your kids go to school. Economic ties refer to your place of business, where your investments are, where you administer your property.
Wait, is center of vital interest basically asking a tax auditor to play psychologist? I mean, if my business, my investments, and all my wealth are in state A, but my spouse, my kids, and my cultural life are in state B, how do they weigh my bank account against my emotional attachments?
It is incredibly subjective, and honestly, it leads to a lot of litigation. But the OECD commentary actually provides a really fascinating recommendation for this exact, highly common scenario.
What do they say?
If your economic and personal ties are relatively equal, or if they are split perfectly down the middle, the guidelines state that your personal acts must receive special attention.
Really? So humanity actually wins over money in the fine print of tax law.
It does. The authorities are instructed to look at where you truly build your life, where you spend your leisure time, where you put down roots, rather than just looking at where you build your wealth.
That is surprisingly poetic for a tax convention.
Isn't it?
But let's say our nomad is single, has businesses in both countries, and splits their time perfectly. A total tie. What is step 3?
Step 3 is the habitual abode test. If they can't figure out where your heart is, they look at your routine. Where do you have a settled, regular pattern of physical presence?
Like day-to-day routine.
Yeah, they look at the frequency, the duration, and the regularity of your stays over a period of years, not just a few months.
And if you are a true global citizen and your routine is equally split between both countries, we finally get to the passport.
Yes. Step 4 is nationality. You are declared a treaty resident of the country where you are a national.
And if you hold dual citizenship in both countries.
Then you reach the absolute bottom of the gauntlet. Step 5. Mutual Agreement Procedure, or MAP. Yeah. The competent tax authorities of both countries literally have to sit down, present their cases, and fight it out behind closed doors to come to an agreement.
That sounds like it could take years. And what happens to the taxpayers' money while the governments are fighting?
It absolutely takes years, and during that time, the taxpayer is often left in a state of deep uncertainty. I mean, potentially facing dual withholding taxes and massive legal bills while they wait for two bureaucracies to reach a consensus.
That's a nightmare.
And it's worth noting, some treaties, like the India-Japan DTAA, actually skip the hierarchy of the gauntlet entirely and go straight to MAP for certain individuals, which is just a nightmare for planning.
And for companies, I assume they don't have a center of vital interests.
For companies, the tiebreaker almost always rests on that place of effective management we talked about earlier. Where is the brain of the company located?
Right.
Though, as the paper notes, some treaties, like the India-US agreement, specifically exclude dual resident companies from the treaty altogether. They just leave them out in the cold.
So we have this neat, highly structured 5-step theoretical framework. But what happens when this framework completely falls apart? Because in the real world, you are dealing with missing paperwork, mismatched calendars, and domestic courts that want to flex their muscles.
Oh, the real world is messy.
Let's look at the actual nightmares, starting with the calendar glitch.
The temporal mismatch is a massive trap. India's tax year runs from April 1st to March 31st. But the US, the UK, and many other jurisdictions use a standard calendar year, January to December.
So you could be a resident in the US for their 2025 calendar year, but you might only trigger that N/or quarantine status in India from April 2025 to March 2026. You basically have a 9-month overlapping period.
Exactly, and that creates a fragmented period of dual residency. You cannot just apply the treaty to the whole year.
Oh, wow.
You have to meticulously carve up your income, isolate the overlapping time frame, and apply the tiebreaker rules only to those specific months. One mistake in the timeline, one misallocated invoice, and you get double taxed.
And what if there's no treaty at all? Like, what if you are a dual resident of India and a country that India does not have a double taxation avoidance agreement with?
That is the absolute worst case scenario.
Oh.
Under Section 160 of the ITA 2025, India does offer some unilateral relief, but it is incredibly limited.
How limited?
Without a DTAA, there are no tiebreaker rules. There is no winner state or loser state. Both countries will simply assert full residence-based taxation on your worldwide income.
And India won't give you that foreign tax credit we talked about.
There is no legal obligation for India to grant you a foreign tax credit for taxes paid to the other country, because the other country is claiming you as a resident, not just taxing you at the source.
So you're just stuck.
The mechanics of unilateral relief often break down right here. You are simply taxed twice on the exact same money, and you have almost no legal recourse.
So what does this all mean for you, the listener? I mean, what does this actually look like if you are the one getting audited? Even if you do have a treaty, the paper makes it clear that it's not a walk in the park.
No, it is not.
It highlights a landmark Supreme Court ruling in India, the Tiger Global case. It used to be that if you had a tax residency certificate from the winner state, you were safe. It was a golden ticket, right?
It used to be. You would present your tax residency certificate and you would fill out a form declaring you were the beneficial owner of the income.
Let's define beneficial owner really quickly.
Beneficial ownership basically means you aren't just a shell company or a middleman passing the money along to someone else. You are the one who actually gets to keep and enjoy the profits.
Got it.
If you had the certificate and made that declaration, authorities used to just stamp your paperwork and move on. But the Tiger Global ruling changed everything. It clarified that a tax residency certificate is only prima facie evidence.
Meaning it's just the starting point, not the finish line? Why did the courts change their minds?
Well, the courts realized that pieces of paper are incredibly easy to buy. Anyone with enough capital can pay a fee, set up a shell corporation in a low-tax jurisdiction like Mauritius, and get a tax residency certificate.
So they cracked down.
Exactly. So the courts had to adapt. They created the doctrine of substance over form. They decided to look at where the actual human blood, sweat, and decision-making was happening, not where the ink was printed.
So you can't just wave a piece of paper anymore. What are the auditors actually looking for when they apply substance over form?
They want proof of a genuine economic footprint. They will demand your company's expenditure records to see if you actually pay rent and salaries in that jurisdiction.
Curiously.
Oh, yeah. They will demand the travel logs of your company directors. They will look at Uber receipts. They will even subpoena your corporate emails and Slack messages to prove where the major strategic decisions were actually being debated and finalized, rather than where the board meeting was formally documented.
That is an intense level of forensic scrutiny.
Mm-hmm.
To really ground how messy this gets, let's look at a wild, real-world case study from the paper, the triple threat.
This is a perfect example of theory versus practice. Let's imagine company XYZ. Based on differing domestic laws, company XYZ is considered a tax resident of state A and also a tax resident of state B, but they don't actually make their money in either place. They make their money in India, which is the source country.
Okay, so India is the source of the cash, and state A and B both claim company XYZ as their resident.
Correct. And luckily, India has a DTAA with both countries, but the treaties have different terms. The treaty with State A says India is only allowed to withhold 10% tax on this type of income, but the treaty with State B says India can withhold 15%.
So if the dual residency between State A and State B hasn't been resolved yet, like, say they are stuck in that mutual agreement procedure fighting it out, which rate does India apply, 10% or 15%?
If you look at the international OECD guidance, it gives a very clear taxpayer-friendly answer. It says that when income qualifies for benefits under two different tax treaties, the source state should apply the lower rate in good faith.
So 10%.
Right. Applying 10% doesn't violate State B's treaty because State B allows up to 15%. But applying 15% would actively violate State A's strict limit of 10%.
That makes perfect logical sense. But the paper gives us a major reality check here regarding the actual humans processing these taxes, right?
Yes, the reality on the ground is completely different. In India, the tax isn't withheld by a nameless algorithm. It is withheld by a deductor.
And a deductor is essentially the local Indian client or employer who is legally required by the government to hold back a chunk of your paycheck and send it straight to the tax office.
Exactly. And Indian deductors are terrified of getting audited themselves. This OECD position about applying the lower rate isn't explicitly written into Indian domestic law.
Ah, I see where this is going.
Yeah, so the deductor is looking at a messy dual residency situation, and they don't want the Indian tax authorities coming after them a year later for under-withholding tax.
The fear of the audit overrides the international guidelines.
Entirely.
Yeah.
So the deductor takes the hyper-conservative approach. They will almost certainly ignore the 10% rate and withhold at the higher 15% rate, or sometimes they will just panic and apply the much higher standard domestic Indian rate.
Which is incredibly ironic. I mean, we have this massive international framework designed specifically to prevent double taxation and offer a fair rate. But the pure friction and fear of domestic enforcement forces the company to overpay up front anyway. So what happens then? Does company XYZ just lose that money permanently?
They don't lose it permanently, but they are forced to go through the incredibly painful, drawn-out process of filing full tax returns in India just to claim a refund for the excess tax withheld.
That sounds awful.
It is.
Yeah.
It ties up their capital for months or years, it requires expensive legal fees, and it creates a massive administrative burden.
It really paints a picture of a system where knowing the theory is only half the battle. You can memorize the tiebreaker gauntlet, you can have your certificates in order, but you still have to anticipate the human behavior of the deductors, the auditors, and the courts.
It is a dynamic, highly combative environment. The rules are just the opening moves of a chess match.
So bringing all of this together, navigating global tax today is no longer just about counting the days you spend abroad, hoping you stay under 120 days so you don't trigger a tax net. That era is definitively over.
It's long gone.
Surviving dual residency requires a flawless alignment of your physical presence, your economic footprint, and rigorous real-time documentation of your daily life and business decisions.
And this raises an important question, one that goes far beyond the balance sheets and the tax treaties. As tax authorities increasingly look past formal certificates, like we saw in the Tiger Global ruling, and demand access to your travel logs, your corporate emails, your credit card expenditures,
Right.
and even evaluate the whereabouts of your spouse and children to determine your vital interests, at what point does strict tax compliance fundamentally infringe on personal privacy in an increasingly borderless digital world?
That is a chilling thought to leave on. When the taxman basically becomes the ultimate invasive biographer of your entire life, well, to everyone navigating these waters, the next time you open your laptop on that beach in Bali, just remember, your IP address might be masked by a VPN, but your tax residency is leaving a very real, very permanent footprint. Keep protecting your income, keep reading the fine print, and most importantly, keep asking the big questions. We'll catch you on the next deep dive.